All right, good afternoon, everyone. Yes, good. So for those of you watching at home, there is a live audience here as well. So good afternoon and welcome to today's panel on a civil justice preview of the Supreme Court's 2025 October term. We are delighted to have all of you here with us. This program is being sponsored by the Law and Economics Center here at George Mason University's Antonin Scalia Law School. It is an honor to welcome our panelists here, who I will introduce in just a moment, to discuss the upcoming cases, particularly those with civil justice-related issues in the upcoming term. There's many competing Supreme Court reviews, but I think there's only one that really says we're going to hone in and focus on how civil justice can be affected, particularly as a result of these programs. Our panelists are also they joked with me when I said this term last time, but they are well seasoned in this, having done this for us for many years. So we're delighted to welcome John Weisner and Robert Peck, Bob Peck, who I will give a more formal introduction to in just a moment. For those of you who don't know me, I'm Donald Kosha. I'm a professor here at Scalia Law School and also the executive director of the Law and Economics Center, who is hosting this program. The panel is designed around our vision at the Law and Economics Center, which serves as a nexus for academic research and programming that highlights relevant economic issues that can help policymakers and judges around the country understand the issues that come before them better and to avoid making the kinds of mistakes that one can make if they do not understand unintended consequences, trade-offs, and other matters. All of this is centered around the belief that when judges, academics, and policymakers understand economics, they are more likely to make sound decisions and engage in rigorous analysis. And our commitment is to developing original, high-quality programming like this one today to make that happen, and it is a delight that we have the interaction of all of you, and your questions and commentary and discussion will also help enrich that exercise. To all those watching on live stream, thank you for joining us today to be part of the ongoing dialogue. You may use the Q&A box at the bottom of your screen if you are online. I have a tablet up here, and I will bring those questions, and we will also be taking some questions from the audience. Our panel today, as I mentioned before, includes John Weisner, who is a partner at Skadden, Arps, Slayton, Rieger & Flom, LLP, here in Washington, D.C. He is the leader of Skadden's Mass Torts Insurance and Consumer Litigation Group, focuses on the defense of reported class actions, mass tort matters, and other complex civil litigation in both federal and state courts. Mr. Weisner regularly handles appellate litigation and has appeared in matters before the U.S. Supreme Court multiple times. Bob Peck is the founder and president of the Center for Constitutional Litigation, PC. He is among the most sought-after appellate litigators with the Plaquemines Par. He's credited with having developed groundbreaking constitutional challenges to laws impeding access to courts, and he regularly appears before the U.S. Supreme Court as well as state Supreme Courts litigating cases on the merits, as well as at the petition stage. They are both very active in the upcoming term and have been in past terms, and so their insights are not only as scholars of the Supreme Court, as participants in the Supreme Court cases, but also as the kind of litigators who understand exactly why the court takes cases and what we should expect from them. So we are delighted to get their insights across the next hour. And I will turn it over to them to take us through the critical cases for review. So, Bob and John, this floor is yours.
So, I feel confident that we are in the right place to do this and will not be called to start over in the Court of Cults. And let me also take a quick moment for a commercial, because since the last time I did this, published this book, Supreme Anecdotes, which is a collection of anecdotes about everyone who's ever served on the United States Supreme Court. So, we're going to start today with the case of Berk versus Choy. Berk versus Choy involves a Delaware law that requires that when you file a medical malpractice case, you also file an affidavit of merit. This is an expert affidavit that affirms that you have reasonable grounds to pursue your case. 29 states require some sort of affirmation of this kind. Often with respect to medical malpractice cases, but other cases involving licensed professions, and others. There's a variety of requirements. Sometimes it's simply the lawyer certifying that he has consulted with an expert. Sometimes, as with Delaware, it is an affidavit from the expert themselves. The question presented in Berk v. Choy is whether a federal court, which is sitting in diversity, must also require the affidavit of merit before it accepts the complaint, because that's the rule in Delaware. Now, often, as most of you know, under Erie, the state law in diversity cases, the substantive is mandatory and followed by federal courts, but federal procedure applies. Now, we have several rules of procedure that seem to be applicable. First, of course, 8 tells you that it be only a plain statement, a fairly simple statement, in order to pass muster as a complaint. In addition, we know that Rule 2 tells you that there are no technical rules here. But more important, Rule 11, which is mostly known for allowing the court to issue sections of prose filing, also says that there's no requirement of affirmation or verification except in certain kinds of cases, for instance, fraud. So, the Delaware rule seems to bump up against the federal rules, which also promise speedy, inexpensive, and relatively sensible types of approaches to justice. This is supposed to be the philosophy that underlies the federal rules. Now, Delaware claims that this is substantive, but of course, that is something that courts always struggle with. What is substantive, what's procedural? They overlap tremendously. Generally, a substantive rule requires you to actually prove something at trial, that it is something that's one of the elements of the cause of action. Procedural rules are the mechanisms to get into court, such as the filing of a complaint. So it seems that, in many ways, this fills the kind of requirement to be procedural in nature, because it is a mechanism that you must have in order to actually file the complaint. That is the issue before the court. Now, there are other practical issues as well with affidavits of merit, subjects of satellite litigation. Is it meritorious? Did the expert really look at the underlying issues and have enough? And of course, when you're filing an affidavit of merit at the earliest stages, so filing a complaint, you're doing it on the basis of allegations. You don't have the benefits of discovery. And of course, if that same expert later appears in the case, the fact that they didn't know about this or that rendered their opinion becomes impeachable material, forcing a lot of plaintiffs' lawyers to seek a different expert for trial so that they don't have those issues. But there's a lot of litigation over validity of the affidavit. There are lots of different kinds of requirements. Iowa, for example, requires that it be notarized. Other states, and under the federal rules, you can do a declaration on penalty of perjury. And so those differences also play out in federal court. So it causes a great deal of confusion. On top of that, what you do is you have difficulty sometimes in getting an expert who, on incomplete information, is going to render an opinion that says that there are reasonable grounds. And so those play into this. And the question that really comes, does this become a barrier to going to federal court?
The issue, I think, in this case is very much the question of whether a state can limit a cause of action. I view this requirement being more part of an element of the cause of action. And a state, I think, wishes to restrict the use of its substantive law in bringing a cause of action under state law. It ought to be able to do so. And it's interesting, the case to me, this all flows out of the Shady Grove case some years ago. And in that case, the Supreme Court ruled, Justice Scalia wrote the decision, that New York had a statute that said that under its consumer protection statute, I think it was, that provided for penalties, the state statute said those penalties were not going to be available in class actions. And the Supreme Court said, nope, that interferes with the federal rule 23 that says if you meet some requirements, you can have a class action. And even though this only pertains to the remedy we're not going to honor in federal courts that restriction. So I think what's will happen in this case is to try to figure out exactly what Shady Grove meant, because it was a very jumbled decision. And let me get into that decision, because I think that's really what needs to be unscrambled here. In that case, there were 4 justices, Scalia and the lead, but 3 other members were still on the court. Roberts, Thomas, and Sotomayor said, let's not worry about this eerie substantive stuff. If there's a rule the Supreme Court is properly authorized in the Rules Enabling Act, and something that the state does collides with that, we're not going to respect. So that's how 4 votes were there for Shady Grove outcome. Justice Stevens, however, took a different position, saying that he supported the outcome, but his view that a federal rule would be improper under the Enabling Act. It could displace state procedural rules that, quote, function as a part of the state's definition of substantive rights and remedies. He agreed that the majority was correct, or the other 4 justices were correct in the New York case, but he took account more of if it was interfering with substantively what the state was trying to do in restricting remedies or access to the courts with respect to a particular cause of action. The only member of the court who dissented from that decision is still on the court as Alito. So I think the outcome will be very interesting, because you have 3 justices who I think, based on what was said in Shady Grove, none of them wrote that decision, it was a Scalia decision, seem to be just saying if it's a Rules Enabling Act, if it's okay under the Rules Enabling Act, it's a collision procedural aid, we're not going to permit it. We'll see where Alito comes out on the outcome of that position holds. So we've got some justices who have not taken a position, and if you think of Roberts, Thomas, and Sotomayor as kind of across the political spectrum on the court, so we'll live and see where it comes out. One thing I would note is that, a few things I would note. The Third Circuit upheld the brief, said that the federal courts should observe this Delaware requirement. And it did so by going through and say this doesn't collide with any of the federal rules, because the affidavit is not required to be part of the complaint. It's something entirely separate. That may be wordsmanship, gamesmanship, whatever. But that was the analysis they did, and they also found it to be substantive. But what it does suggest to me is that if you're a member of a state legislature and you want to really put a cause of action, there's this game you have to play, and that is figure out a way to articulate your goal without touching any of the federal rules. And it seems to me to be just that again. There fundamentally ought to be a way in which state legislature could say, we want to limit a particular type of cause of action without tripping over what is being argued in this case to negate what Delaware decided to do.
There are 2 things that I want to point out in response. One is that this case was filed by a pro se litigant. So that also colors the way it is, because courts try to go out of their way to enable a pro se litigant with a legitimate case to proceed. And the Delaware law actually says that the clerk of the court cannot accept the complaint if it's not filed with this affidavit. So the affidavit cannot be used for any other purpose during the course of the case, except potentially for impeachment purposes. And so that also leads me to say that it's not really an elementary case. The second thing that I want to point out is that the court has been making noises in the last few years about the fact that maybe Erie wasn't correctly decided. And so that also throws a new wrench into the works of how you look at what the court might do.
Well, let me move on to our next case, which is Hain Celestial versus Palmquist. And I will start by pointing out that this is a case about baby food. It's not just any baby food. No, we're talking about Earth's best baby food, which is organic food product. In this case, the plaintiff sued the manufacturer, which is Hain Celestial, alleging that the baby food contained heavy metals in trace amounts, and that caused their young son to develop autism spectrum disorder. The lawsuit was originally brought in Texas State Court, which is where the plaintiffs resided. Hain Celestial was diverse with plaintiffs, was one of the defendants, but they also named Whole Foods, which was not diverse with them. Hain Celestial removed the federal court in the Southern District of Texas, arguing that Whole Foods had been fraudulently joined, that they played no role in the manufacture of the product, and therefore should just be ignored, and they were dismissed. Now, I should note, key fact, when the removal was taken, plaintiffs filed an amended complaint trying to make a better case for the presence of Whole Foods. The district court said it couldn't consider it. It had only look at what was there in the original complaint. Time of filing rule applied. And since the original complaint didn't say the culpable claim, that Whole Foods should be ejected from the case. So Whole Foods was dismissed. Plaintiff didn't seek review of that dismissal. So the case proceeded. So there was more than a year of discovery. There were 20 fact and expert depositions, cross motions for summary judgment, many motions in limine, the whole 9 yards, much expenditure on this case, which was sort of, I won't say bellwether, but there was a lot of investment in this case because of possible ramifications for future cases. And it finally went to trial after attending for 21 months. The plaintiffs put on 7 days of testimony for the part of the case. And 2 days after they rested their case, the court granted Hain's motion, Rule 50A motion, on the grounds that the plaintiffs had failed to present sufficient evidence of general causation and ingestion of heavy metals in this amount couldn't have caused plaintiff's condition. So plaintiffs appealed to the Fifth Circuit. The circuit didn't address the merits of the dismissal at all. It just said, you don't get to keep that tape nothing judgment, because you got it wrong in terms of the dismissal of Whole Foods. And Whole Foods is there wasn't diversity jurisdiction. And so after this very lengthy period, they said, go back to state court, start over. So that's what happens. And that's where we are arguing up at the Supreme Court. The decision creates, from everything I can see in the papers, a very clear circuit split. 4th, 8th, and 9th Circuit told that when it's determined on appeal that a non-diverse dispensable plaintiff has or should have remained in the case, final judgments should be preserved. Basic position is the final judgment shouldn't be vacated. And I think a rationale of those cases is you take a snapshot of the case at the time of judgment, and if there's diversity of the parties that are in the case at that point, then jurisdiction should be preserved. And whatever outcome is occurred should be upheld. And in those decisions, there's an enormous stress on the amount of waste that would be involved if, as in this case, after multiple years actually getting well into trial, the court just says, oh, you gotta go back to state court and start over. In this case, however, the Fifth Circuit joined the 11th Circuit in coming out the other way, and I think that decision reflects what you normally see in cases, which is a very rigorous view of the federal courts and no business being involved in a case where there isn't clear federal jurisdiction. And so that's the tension that is there. That's the debate that will occur in the states. And it really is a battle between, is it really fair after all this time to send parties back to state court after a full investment in the case that has state review for whatever reason, and I think that will be the debate there. The briefing I find somewhat confused because it goes off on a tangent about whether there was waiver because the plaintiff didn't seek 1292B review, and I don't think that's really what's at issue here. It's really about, I think the question before the court is what remedy should be imposed if you get to this stage and a jurisdictional defect is found that was not of the record at the time of trial or whatever the final disposition may have been.
So this is a case that at one level is about subject matter jurisdiction. Obviously, federal courts have subject matter jurisdiction if it arises under a federal question or a federal law, or as a result in diversity. So we have the Fifth Circuit saying that Whole Foods should never be dismissed, and under a very traditional approach to subject matter jurisdiction, that meant that the district court had no subject matter jurisdiction, and as a result, had no authority to rule on anything in the case. That, of course, is the position that the Fifth Circuit took. The Supreme Court may look at it differently, and although Jones says it's a side issue and may not figure, there is great emphasis on whether or not there was an obligation on the part of the plaintiff when Whole Foods was dismissed from the case to ask for interlocutory review and seek review in the Fifth Circuit position. Now, it's discretionary with the district court, and it's still discretionary with the Fifth Circuit on whether they take it. Traditional view is that plaintiff is under no obligation to do that. At that point, the final judgment rule really does apply, and you have to wait until there's a final judgment case. It seems like after 2 years and a jury trial that a lot of resources, effort went into it, but then again, we see that all the time. In cases involving, for instance, supplemental jurisdiction, where you assume that there is a federal cause of action that's applied, eventually you get to the U.S. Supreme Court and they say there's no implied federal cause of action. And because of the supplemental jurisdiction statute, you are sent back to state court to retry it under state law, and many years can go by. So it's not unusual that the rules, which basically require you to dot the I's and cross the T's, will do that. The question, of course, is whether those equities change the way that the Supreme Court looks at it.
Bob, before you move on to the next case, could I ask you a question on this? So what role do the court's cases on hypothetical jurisdiction and the refusal to take hypothetical jurisdiction and just sort of a pure power issue play in this? And then second, how do you see the concern, the prudential concern over gamesmanship at manufacturing jurisdiction playing as a background principle that might lead to caution of continuing or allowing to stand a case once diversity, for example, has been eliminated?
You know, I would think that, just to answer the second question, that gamesmanship probably doesn't figure in this case because the Fifth Circuit was pretty clear that this was not fraudulent tender. That, indeed, Whole Foods was properly brought in as the seller of the product, and as a result, you'd have to have a lot more evidence than appears to be at issue in this case, to claim that there's some sort of gamesmanship going on.
No, I tend to agree with that, but I would say more generally, in a lot of cases, and I think that's the source of your question, there is some gamesmanship about naming an additional defendant to prevent access to federal jurisdiction. Indeed, that's what prompted years ago the enactment of the Class Action Fairness Act, because basically by manipulating naming of local parties in nationwide class actions where they obviously played no role, some plaintiffs' counsel in those states were able to keep virtually all class actions that didn't say the federal claim in state courts. So I don't want to say it's absent, but it seemed to be a crisp.
And I'll point out that it goes along with, to quote Justice Scalia, a plaintiff being the master of their complaint, trying to design the complaint to stay court, avoiding federal questions by assuring that there's diversity rather than go to So our next case is Chevron versus Plaquemines Parish. This is a case in which 43 different lawsuits were brought by various Louisiana parishes over the exploration and development of oil along their coast. What the oil companies that pursued have claimed is that they had contracts with federal government during World War II. And as a result, that made them eligible to remove the cases to federal court from state court. Now, you'll see that this term, the court has a number of these removal issues before it. Obviously, very interested in that issue, and we'll be talking about federal officer removal in a while. But the question here is, how much connection must there be between those World War II contracts and the alleged offense, the injuries here? What we see is that Louisiana says that there is a minority, just about a quarter of the areas that they have sued on, that involve areas that were subject to contracts, and that only a small percentage of those explorations have anything to do with the contracts. So as a result, it really isn't a big question, and that can be sorted out in some way through the trial itself. But the oil companies all claim that, they were essentially working at federal direction, even though there wasn't a lot of specificity about that. And so as a result, they should be able to remove it. Now, they removed it under the federal officer removal statute. That's 1442A1. In that statute, it says a defendant must show a colorable federal defense, is a person within the meaning of the statute, has acted pursuant to a federal officer's directions, and the conduct is connected or associated with an act of the federal officer's direction. But in 2011, Congress amended the act, and they basically said that, well, if it's an act relating to, or act for, or relating to color of the federal office, then it may be covered by the federal officer. Now, to understand this, it's important to also understand that there are a number of different ways that this issue has come up before. One of the prime decisions is Watson versus Philip Morris, in which Philip Morris claimed that it was a federal officer for purposes of testing tar and nicotine in cigarettes and putting it on their packages. They were sued in that case over their claim that their cigarettes were light cigarettes and had reduced tar and nicotine, when in fact they did not. They wanted to remove the cases to federal court. They said that the FTC used to do this particular method of testing for tar and nicotine. When the FTC dropped doing it, Philip Morris voluntarily undertook to do so. And as a result, their doing it by the FTC method essentially made them a federal officer. The Supreme Court unanimously held against that. We've also seen Boeing, for example, claim that they're a federal officer for purposes of removal because the FAA issues licenses to them so that they can certify their planes as airworthy. And so they, in the case involving an aircraft crash that came up in the Seventh Circuit, they basically said, we are a federal officer, we should be in federal court, not state court. And in the opinion written by Judge Easterbrook in the Seventh Circuit, he basically called that frivolous. It says to self-certify is to say even a lawyer who files a complaint in federal court is certifying the validity of the complaint, and that makes him a federal officer. That's ridiculous. And basically warned that anyone making that claim again would be making a frivolous argument. A couple of years later, I had a case in front of him in the Seventh Circuit, where a nursing home, as a result of COVID, claimed they were federal officers because it was all hands on deck, and as a result, they should be in federal court, not in state court. In the Seventh Circuit, you don't know your panel until the morning of the argument. And So I did not know who would be on my panel, but it was a good Seventh Circuit decision. So I said that they didn't even have as colorable a claim as Boeing did in the Boeing case. Well, turns out presiding on that panel was Judge Easterbrook, who, when my opponent got up to give his oral argument, Easterbrook started out with my opening sentence that it's not even as colorable as Boeing's argument, and says, how do you respond to that? And then didn't let him answer. Took the remainder of his 15 minutes excoriating him. I didn't know what I would have to say in my response, and there's quite a distance between the council tables and the podium. And so as I'm halfway to the podium, Judge Easterbrook says, you cited 105 district court decisions at 3 federal circuits in support of your position. Have there been any more decisions since you filed supplemental authority? And I said, well, as a matter of fact, yesterday there was one more circuit court. Okay, there are 0 on the other side. The only other question I got was, do you want us to write this broadly or narrowly? So, when it was over, at least my board-yard, less than a minute, when my opponent got up saying that he had reserved some time for rebuttal, Easterbrook simply said, no, you didn't. So, courts are reluctant to grant this kind of federal officer removal. In one instance, it was granted in a case in the Fourth Circuit where a mold removal firm was removing mold from the Charlotte airport. There was a federal officer directing them, telling them how to do it, and supervising it every step of the way. They were regarded as federal officer now, fully fulfilling that thing. Here, it seems to be an odd thing because it's based on a contract that exists during World War II. When these lawsuits were brought, of course, that was long in the past, and their assumption is that because World War II, we needed oil production and they were fulfilling that duty, it continued all the way. It seems like an odd fact pattern in which to raise this, but the court is interested in it. They obviously have granted cert, and so therefore the question really is, what is the effect of that 2011 amendment?
Yeah. Here's a couple of points on this. Bob is correct. The courts have gone different directions in interpreting the federal officer concept. But I think it's important to note, he referenced correctly the Removal Clarification Act of 2011. But what's interesting is Congress keeps broadening the federal officer concept. And so whenever the Supreme Court has come down with a decision that appears to be restrictive, Congress in the past, I'm not predicting what would happen today, but so don't hold your breath. But there's a pretty consistent pattern that Congress wants this federal officer concept to be interpreted broadly. And so that's the countercurrent that is existing here, to the extent that the court wishes to carry out congressional intent. All the signals are do this broadly. And again, it's not purely, I mean, it's really not substantive. This is really a question of which court. I find it interesting, just as a matter of history, where this concept came from. It dates back to Civil War days. Yeah. But I mean, a lot of this was to protect persons who perform services for the federal government but fear reprisals from state courts. Strangely enough, this may be a case through which that's legitimate because it is a local controversy, a local court that be coming in. And so some of that historical concern may be more prominent here than it is in your classic diversity jurisdiction case, which has the similar motivation. I do want to note, though, part of the reason Congress keeps expanding this, though, is that in negotiating federal contracts, basically the government buying stuff, this is a major issue because if the seller is concerned about litigation coming their direction as a result of performing the service, the price goes up. And so part of the reason for Congress expanding federal officer jurisdictional considerations here is exactly that, is I think a motivation to try to keep prices down. The last thing I'll note is I find this to be one of the more fascinating removal grounds that are out there. And I will say, as a defense lawyer, this is probably the area of perhaps maximum creativity. If a client says to you, I don't care what it takes, we need to get this case removed to federal court, you'll go through your normal diversity jurisdiction analysis, can these people be knocked out, all that sort of things. But at some point, somebody will be set off to the library and say, can you come up with a federal officer theory? Is there any part of this that connects to the federal government in some way? Is anything involved in contract? You were suggesting Courier, that's where the Boyd arguments and so on came from. And it's sort of a pocket of last resort. But often you come up with a theory that works, that there is a connection, and particularly when the 2011 Act says you can remove an action for or relating to any act under color of such office. That is pretty broad. When you have for relating to, my God, that's opening the floodgates.
So let me just say one reason, of course, a defendant might also seek removal under federal officer removal is because there's an automatic right of appeal of that interlocutory order. So if your interest is in delay, that's a great way to do so. But I will point out that the first federal officer removal statute was 1815 now, and it was because of New England's resistance to cooperating during the War of 1812. The idea was, of course, that state courts were prejudiced against the representative of the federal government, and so therefore it ought to be tried in federal court. Now, as John says, the 2011 amendment sounds very broad, but it's also very vague. Yeah. And the question then that I expect justices to ask during oral argument is, what's your limiting principle? Where does it stop? Because that's something the court will always ask. Now, sometimes you can get away by saying that's not this case in other courts, but you can't get away with that in the Supreme Court. They want to know the ramifications of the decision that you're asking them to run.
I asked you both to just briefly do a tutorial on this because I think for the benefit of some of the listeners and some of the audience, including I see some first years out there that probably a little bit of this is going over their heads. So if you can explain the plaintiff being the master of their complaints and when can someone normally remove versus an exception, so that the fact that these are exceptions to the normal inability to remove if there's not a federal question on the face or cards of the complaint, and the idea that federal defenses on their own do not give you a right to remove. Could you just say a couple of things about what's the baseline against which this is being challenged?
So let me start with the plaintiff being the master of their complaint. When a plaintiff has a case, they're looking at what causes of action they might be deliberating. They are making a decision about whether to go to federal court or to state court. In personal injury cases, most plaintiffs prefer to be in state court because they're more familiar with it, and as a result, they think that they'll get a better case there. Often, defendants prefer to be in federal court. It's something also that they're more familiar with. The rules are perhaps not as flexible as in state court, and so there is this battle of whether to remove the case to federal court that has been filed in state court. What the Scalia decision said is that if a state court plaintiff chooses to avoid all federal issues, then what it means is that they have a right to say that I'm not suing under those grounds, even if it is a defense. There's an affirmative defense based on federal law. It doesn't mean you get to go to federal court. It means the plaintiff gets to sue where they chose. Now, if there is a disguise for the federal question, if there really is a federal question lurking there that has to be answered in order for the state liability to exist, that's a removable issue. If there is diversity, obviously, is another grounds for which federal subject matter jurisdiction exists. So if there is a reason to bring the case because there are diverse plaintiffs, complete diversity, then indeed it can be removed to federal court. And once it's removed to federal court, you're in federal court trying to get a remand if you're a plaintiff. You're trying to defend the removal if you're a defendant.
Couple things I go to final point on the notion about why plaintiffs want to be in state court and defendants want to be in federal court. And the final point is a way to put it. I just think they're going to get a better outcome in state court. Generally, not always, generally. And defendants think they'll do better in federal court. It's the rule of thumb. I'm not saying it's true in all cases. It may depend on the state they're talking about and so on. But it's not so much familiarity with the court, because half the time the case being filed in state court is being filed by out-of-state counsel working with local counsel anyway. So it's just work.
EBQ in last points of the other cases.
They're being kinder about that. But I think that's the rule of thumb. And so if you're on the defense side, and this very carefully crafted complaint is filed with Justice Scalia's blessing, then what you're doing on the defense side, as I was suggesting earlier, is figuring out for your defense side client, how can I get this to federal court? And as Donald was suggesting, you go her first and try to find a federal question working somewhere. It doesn't have to be stated in there, and they may have, for Justice Scalia's efforts, be very clear, we're not asserting anything under federal law, but often that just doesn't work. It's too clearly implicates federal law, so you do have a ground for removal on federal question. Then you turn to diversity jurisdiction, and as I was suggesting earlier, you look through to see if all of the parties that destroy diversity should be in the case. And you get rid of anybody in there that destroys it, should complete diversity that would give you a ground to remove. And then one of the other areas you go to on the checklist is federal officer, which is what we've been talking about. But I think that's really, and in a very simple nutshell, the analysis that you're going through in litigating these cases.
Thank you.
Well, let me move on to our next case, which is Coney Island Auto Parts v. Burton. I also was here every time I see that I get hungry for a hot dozen. There's nothing to do with that. And this is a good old civil procedure rule interpretation case. Not a lot of bells and whistles here. It's what do the words in the rule mean? And the rule at issue here is Federal Rule 60. Which is outlining you spend as much time looking at Civ Pro as you do other rules, but it is important. Rule 60b4 says that a court may, I'm quoting now, relieve a party of a final judgment, order, or proceeding for any of 6 reasons. And one of those 6 is the judgment is void. And that's Rule 60.4. So if the judgment is void, that's ground to move under Rule 60 to relieve the final judgment. And Rule 60C, which is the key rule here to be interpreted, says that a motion to relieve, quote, must be made within a reasonable time. Okay, very specific. Reasonable time. So, question presented in this case is, what does the phrase within must be made within a reasonable time mean? Petitioner in this case urges that, with one exception, each circuit has held that language means there isn't power. There's none at all. And the one exception is the 6th, which ruled against them in this case. But that's the position of the petitioner. I'm saying it's right, but that's the circuit split, 12-1. I think the papers say, and that is what was presented to the court as basis for taking this case. Before getting to whether that split is really there, I need to just note that this case has a long, complicated history, which I'm not going to go through in detail. The highlights are as follows. It basically, this controversy arose out of a Chapter 11 bankruptcy proceeding in which the debtor sought to collect an unpaid debt by our friends of Coney Island Auto Parts, the petitioner here. At some point, the Tennessee Bankruptcy Court entered a default judgment against them. That was back in 2015. After 6 years of collection efforts, Coney Island finally engaged on this issue, responded to the efforts to try to collect from them. When a hold was placed on accounts by a bankruptcy court in the Southern District of New York, Coney Island then moved that court to vacate the judgment, but the Southern District of New York Bankruptcy Court said no, it came from Tennessee, so you go back to Tennessee and try to get it lifted there. So 6 years after this whole thing started, and 6 years after conceitedly being on notice of this default judgment, which Coney Island claims is void, they moved the Tennessee Bankruptcy Court to vacate, and the voidness is based on lack of valid service, personal jurisdiction argument. So the Tennessee Bankruptcy Court assumed that the judgment was void, so that box was checked. But it denied the Rule 15 motion on the ground that it was untimely. That was a bankruptcy court's decision. It was then affirmed by the district court. And then the Sixth Circuit affirmed. So all the courts in the chain agreed about this. And the Sixth Circuit rejected Coney Island's argument there that there was, that Rule 60B has no time restriction at all. They move within a reasonable time, moves whenever you feel like it, basically. A dissenting judge, though, on the Sixth Circuit said, I don't see in Rule 60B an exception. It says within a reasonable time, so don't you need to decide whether what happened here occurred in a reasonable time. And in dissent was saying, no, it was not agreement on that point. If you read the briefing, I frankly think that the party opposing the cert petition really made mincemeat of the petitioner's argument that there was a 11-1 split and went into detail in each circuit of a long list of decisions from each circuit dealing with this issue. Well, it's interesting, though, if you read through those cases, you sort of say, gee, there's a lot of split in the circuits, because some of those decisions in the circuits seem to say, as the Sixth Circuit did pretty flatly, there is no time limit. Others said, we need to look at whether the motion was made within a, quote, reasonable time, and sorting through the facts to see if that was the case. And indeed, in all the circuits that were cited, there were instances where these motions were denied as being untimely. So I understand that what the court typically does in deciding whether to grant review is looking for a split in the circuits. But when you read all this, you have to sit there and go, since there doesn't appear to really be a clear split, you wonder if the court said, thanks to the briefing of the party opposing cert, this is kind of a mess, as the circuits within themselves are all over the place. No meaningful clarity on this. I don't know if that's what happened. I don't mean to suggest that. But you read this, the exchange of the petitions, you sort of wonder, how did the court get around to granting review? I mean, one suspects, I had the feeling the court can't ignore this reasonable time language. I don't see the court saying there is no time limit. I suspect it will be a somewhat unsurprising declaration that no, you do have to look as to whether the delay was reasonable. and provide some guidance on that. But it's a very, it's a suitable question. It's interesting how and why the court took this, because the circuit split is dubious, at least in my view. But there is a lot of uncertainty in the courts about how this rule ought to be interpreted.
So let me start by addressing that, because although Donald said that we have a pretty clear view, having been working with the court, before the court for many years, on why they take certiorari, I got to say that no one really has a clear view. What it may be true one term is not true the next term. And years ago, I was involved in a First Amendment case where all the case law was on our side. We won at the district court level. We won in the Eighth Circuit. We had opposed certain Supreme Court saying there was simply no conflict whatsoever. This is a settled question. And the court took the case, which made us wonder, does that mean that they're going to tinker with the precedents that we thought were so well established? No, they just need to reaffirm it. And they did so in a, flowery decision that basically said, yes, we were right all along. So don't know. Here, it is a mess. And maybe they want to try to lend some clarity here. That's possible. But I think it's also important to understand exactly what 60B says. Because while it says that the motion must be made within a reasonable time, it does say that for reasons 1 through 3 out of the 6, it should be no more than a year after entry of judgment. Now, 1 through 3 involves mistake, inadvertence, or surprise. 2 is newly discovered evidence. 3 is fraud. So that's not the judgment is void. I had a case in the Eastern District of Missouri where 2 years after the decision, the defendant filed a Rule 60 motion claiming that the judge had made a mistake. No, in this instance, they actually filed it exactly a year afterwards. So they were within that no more than a year. But the Eighth Circuit has defined reasonable time as 30 days. So if you knew about it within that first 30 days, you were obligated to do so. They hadn't read the case law, they simply read the rule. As a result, they were out of time, even though also they were wrong that there was any mistake. So there's a lot of confusion within Rule 60 because of that, because you have different circuits coming up with different rules for what is reasonable. The whole idea behind the federal rules was to create some sort of uniformity so that you wouldn't be guessing from jurisdiction to jurisdiction within the federal system. So that is the problem that perhaps they want to address. The other interesting fact, just to emphasize that John touched on, is that the petitioner in this case claims that they were never served with the original papers. So therefore, there was no personal jurisdiction over them. Personal jurisdiction means that you have authority over the person. So therefore, they claim that the default judgment was invalid. Now, they did have actual notice at some point. Maybe not at the original point. And I think the court is going to end up focusing on the actual notice as being the trigger for what could be reasonable.
So we have just 7 minutes left. I know you both have a brief remark on 2 cases, one each. Do you want to move to that?
Or why don't we open it to questions, because we only have some.
Sure. Are there any questions from the audience? And remember, if you're online, you can submit a question using the Q&A box at the bottom of the screen. Yes, all the way in the back.
Sure. Will you speak briefly?
There's a microphone so that the people online can hear you as well.
Thank you. Will you speak briefly to the impact of the shadow docket on the regular docket?
All right. Well, first of all, we don't know what to call it. It's either shadowy, emergency, or interim, which justice you're talking to. But it has now dominated the court's docket in a way that no one would have expected just a few years ago. And as a result, it is triggering us in all kinds of different ways to try to understand what the court is doing here. Because you have Justice Alito having said that it is not precedent, that many of these decisions are essentially a paragraph log and procedural in nature, giving you no substance. And then you have the court excoriating a district court for not following one that gave them no guidance at all. Meanwhile, we know that it doesn't overturn existing decisions, and the Supreme Court has made it very clear that they're the only ones who can overturn a decision, and no matter how much we've suggested that this is no longer good law, you lower courts still have to follow it. So as a result, we have something that we can't put our fingers on. We don't know what to do with it. I was mentioning that one of those shadow docket decisions mentioned a in-chambers decision Justice Scalia issued in one of my cases, in which they used it for the purpose of it was okay to grant a stay. In that particular instance, he granted the stay, and then the court denied cert in the actual case. So it upheld the decision I was defending. So again, of all the possible citations that they could have made, it seemed like an odd one for up to years. So as a result, I can't answer your question. We're all scratching our head as well.
Yeah, I'm not sure everyone's focusing on the shadow docket, but and I agree, it's created a lot of mystery, it's suspense, uncertainty. But I'll step back and say, as we were referring to earlier, we also don't ever fully understand, for example, why they grant cert in a case. I mean, particularly in the last couple of terms, we've had so many where they granted cert on these boiling issues that everyone wants an answer to it, and they say, oh, it was improperly granted, when they get into the facts, and you go, why didn't somebody notice that earlier?
And we work you on that. Sure. You know, one of the things that is a mystery about the court is you can tell them very clearly in your opposition to certiorari that this is a problem and this is not a case you should take. And then they still order full briefing and argument and then decide that it was improperly granted on precisely the grounds that you opposed cert in the first place. That makes it very hard to understand.
I do have to say that I keep coming back to the principle. I was talking to a couple of friends the other day about the shadow docket, and one of them said, oh my God, the shadow docket is just so contrary to the rule of law. And we step back and said, no, I'm sorry. You may not like it, and you may think that the whole process is misguided, and you're entitled to your opinion, but the Supreme Court establishes the rule of law. And so we may think they're wrong in what they do, but it is the law. And so I think we all share the uncertainty about what everything that's going on there. But it's just one of the mysteries about the operation of the court.
But as John said earlier, the court normally, the primary criteria for taking a case is a conflict among the circuits. But it also takes cases of national importance. And what we're seeing is most of the cases of great national importance moving into the shadow docket, and maybe at some point, maybe not, getting to be the merits.
So I might add that not only do we have a mystery of why they take some cases, we certainly have a mystery of why they don't take the fast. I mean, there's a lot of cases they don't take as well, that they don't explain why they don't take those. And let me just offer one thing, that perhaps at the time that the discussion began about the so-called shadow docket, it was slightly unknown. But I would say that at least in terms of media coverage and everything else, the shadow docket gets more coverage than the regular docket at this point in time. So I'm not sure it's actually lurking in the shadows in any way at all, but instead it's the greatest deal of sunlight out of all of these. Mr. Thetford, I think you had the next question.
All right. Thank you both for sharing from your experience. It's been really helpful. I had a question about the Trump v. Tosic case from last June. Just from my observation, it seemed like, just to summarize in this case, the court said federal courts can only grant complete relief to parties. And it seems already has been a divergence among some of the districts and how they apply complete relief. What does that mean? So my question for you is, do you think this is a settled issue that the district courts will figure out how to apply complete relief in a consistent way, or do you think this is an issue that's going to simmer back up to the Supreme Court for clarification?
I've always taken the position that every decision of the Supreme Court simply inspires new cases before them. I think that this will end up going back to the court. I think that there's lot of questions that were unanswered. I think you're finding district courts looking at where the open questions are and perhaps walking through that maze to some extent. And I think that the court is going to be forced to come up with something. I frankly expected a more nuanced type of decision from the court on that, because here we had a precedent that was binding on the courts, and so therefore that somewhat suggests a different analysis than a case that's a novel issue. The court didn't go in that direction. My guess is that that's going to be raised at some point, and whether the court then adjusts in light of that is an open question, but I think they're going to be forced to face it.
Yeah, I agree. I mean, if you look at, I don't know if I should add to that, but if you look at any major decision of the court, it never answers all the questions, and we always are relitigating issues coming out of that. And even when something appears to be crystal clear, litigants will find a way to find a new approach, and you'll have it back before the court at some point, maybe like immediately.
Sometimes even in the same case. I once had a case that went up 3 different times, and the cop, before you go into oral argument, the clerk of the court meets with you, no matter how many times you've been there, to go over the rules and some suggestions about decor, things like that. And turned to me and said, "Are you trying for the record?"
So I apologize to those who have continuing questions in the audience, as well as the questions we didn't get to online. But we are at time. I do, though, want to exercise moderator and executive director prerogative and say we're going to go over by less than 3 minutes by offering each of you 90 seconds to, as we've done in the past, tell us any final wisdom that you think we should walk away with, and that includes any petitions that you're watching that the audience should be looking for this term as well.
Go ahead, Bob. I can't resist pointing to one of the petitions I have ended. Just yesterday, the Solicitor General's office asked for a second 30-day extension of time to oppose the petition. But this is a case involving PLACA, which is the Protection of Lawful Commerce in Arms Act. This is a statute that provides immunity to gun manufacturers and dealers for the sale of guns, inspired by the fact that a number of municipalities brought actions against gun manufacturers over the way that they would dump guns on gun shows, and they would end up in criminals' hands. But the way that PLACA works, and this is an issue that I think makes it more interesting than just guns, is that it requires a state to pass a statute that gives the right of this kind of action. It's called the predicate exception. If the state does that, then PLACA doesn't apply. But if it is a function of the common law or a judicial ruling, there is immunity. Now that seems to me to dictate to the states how they exercise their sovereign authority. And as a result, what it is telling the states, you can pass laws through your legislature. We're Congress, we respect fellow legislatures, but we don't respect judges or juries or the common law. That seems to me a violation of the 10th Amendment. That's the grounds on which we have sought it, review, and we may not make it this time because sometimes, as you say, they cert, but then they accept the issue somewhere down the road. But I think it's a very important issue in terms of how Congress tries to control litigation in the states.
And the name of that case?
It's Gustafson versus Springfield Inc.
Thank you.
Donald, I won't spotlight a particular case, but there's kind of a looming question in my mind about, we've talked about the shadow docket before. I'll leave that aside, but I'll refer rather to the executive order docket, which is on the record and before the court. I'm just curious to see how much the court is diverted away from the normal flow of business coming up from the circuits on a wide variety of matters and feels obliged to divert to issues are put before the court by the current administration. I not say there's anything wrong with that diversion, if that occurs, because these are issues that require the court's attention. But there's one customer who seems to be getting a lot of the court's attention, not only on the shadow docket, but these matters are then put on the regular docket as well. And you just wonder how much capacity the court has to deal with all those cases, which are in a growing number, as well as the other issues that have no relationship to the federal government on which the owner are filing petitions. We were noting earlier that this has not been the normal summer for the Supreme Court by any stretch of the imagination. I think we all think, I don't know if it's true or not, that summer is a time when the court activity diminishes significantly. A lot of the justices teach or do other things during the summer months. But I doubt that it's been a very relaxing summer for any of them, given the number of issues on the shadow docket or whatever else may have arisen. It's been a very busy time for the court, and you just wonder how much capacity there is to deal with those issues that are being raised, plus the normal business.
Thank you. So you've been attending, and for those at home, you've been watching the Law and Economics Center at George Mason University's Antonin Scalia Law School's Civil Justice Preview of the October term 2025. We are delighted that all of you could join us in the audience, and those online, and those who will be watching this later in time. And let's thank Bob Peck of the Center for Constitutional Litigation and John Beisner of Seattle for presenting today.